Good morning. My name is Chris Ritchie, and on behalf of Huntington Bank, I want to welcome you to day 2 of our Class Action Money and Ethics Conference. Yesterday, we had a terrific program with Brian Fitzpatrick as our keynote speaker, followed by panels on data technology and privacy and mass arbitrations. Now today, we have 3 interesting panels scheduled. The first will be about antitrust. The second panel will discuss ERISA, labor and employment. And the third panel will cover securities. Now let me introduce our conference co-chair, Jeff Klenk, Director at Berkeley Research Group.
Hi, thank you, Chris. And on behalf of Berkeley Research Group, I would like to welcome everyone to today's conference. And for those of you who joined us yesterday, thank you. And I am sure that those of you who joined us yesterday were as impressed as I was with Brian Fitzpatrick's presentation. At some point, I emailed Chris in the middle of the presentation saying, this is a home run. Brian is fantastic. So I definitely enjoyed it, and I hope everyone who had a chance to hear him yesterday enjoyed it. And if you didn't have a chance to hear Brian yesterday, please know that each of the panels will, within the next few days, be posted to the Class Action Conference website. My understanding is that those panels haven't yet been posted, but should be available shortly. And I understand as well that Brian didn't get a chance to answer all of the questions that were posed to him. So I know working with Chris and the Beard Group, we are hoping to find some mechanism to present some of those outstanding questions to Brian so that he can share even more insight with us. As I noted yesterday, one of the things I really value about this conference is the fact that it brings together practitioners on both sides of the V and really works to ensure that opposing viewpoints are heard. And so I know as a panelist on the upcoming antitrust panel that we definitely will have some diverging opinions. And I am really excited to hear what some of my colleagues on the other side of the V have to share. So with that, let me turn it back over to Chris to introduce this panel.
Okay, thanks, Jeff. Before we go to the panel, we do want to thank our presenting sponsor, the Beard Group, and our supporting sponsors, Alert Communications, Broadridge, CPT Group, Dundon Advisors, Pacer Monitor, and Top Class Actions. As Jeff mentioned, the session is being recorded, and on the same website where you'll be able to see the links of those videos, you will also find background materials for the panel discussions, including the Antitrust Annual Report that we'll discuss here shortly. Our program will continue today and tomorrow from 11 a.m. to 2 p.m. Eastern. During these panels, we invite you to submit questions through the Q&A icon that you see on the bottom of your screen. And we encourage you to pose questions because it makes the program much more interesting for both the panelists and for the participants. Now, it is my pleasure to introduce my colleague, Rose Kohles, Associate Director at Huntington Bank, who will moderate our first panel, an analysis of the antitrust landscape over 10 years. Rose?
Great. Well, thank you, Chris and Jeff, for introducing us this morning and for introducing the panel. My name is Rose Kohles, and these pieces as kind of a sneak preview. They have not been published anywhere else as of yet. The first is the 2019 Antitrust Annual Report. The report is published in partnership with Professor Josh Davis at the University of San Francisco Law School and Huntington Bank. The first of its kind, the Antitrust Annual Report analyzes private class action lawsuit settlements in the United States federal court system to better understand how class action litigation is changing and how those changes affect class action professionals. The second attachment is the American Antitrust Institute's The Vital Role of Private Enforcement in the United States, which comments on the report's findings and is written by Diana Moss of AAI, Laura Alexander of AAI, and Professor Josh Davis of USF. Joining me this morning for the panel are 4 esteemed professionals in the antitrust practice, and I'm going to introduce all 4 of them now so as not to interrupt some of the dialogue that we'll be having later on. First, we have Professor Josh Davis. Professor Davis teaches at the University of San Francisco Law School, where he serves as the director of the Center for Law and Ethics. As director, he leads panels, organizes symposia, and undertakes research exploring these topics. His scholarly research focuses on complex litigation, ethics, and the interplay between the two. Davis is active in law reform and also writes extensively about antitrust and free speech law and is on the board of AAI. Next, we have Pamela Gilbert. Pam is a partner at Cuneo, Gilbert, and LaDuca and has over 35 years experience in advocacy work in Washington, D.C. She has testified over 50 times and has made dozens of appearances in the national footprint and electronic media. Gilbert focuses her practice on government relation matters. She represents a wide variety of clients before Congress, the executive branch, and regulatory agencies. She is one of the leading advocates in Washington, D.C., working to preserve access to the civil justice system for both individuals and businesses. Finally, returning to the panel, we have Nathan Ament-Stone, who joined us last year at the Class Action Money and Ethics Conference and was quite popular, I'll say. He is an associate at Curtis, Mallet-Prevost, Colt, and Mosle. Nathaniel focuses his practice on antitrust, complex commercial litigation, and arbitration. Nathaniel has represented clients in the commodities, sports, insurance, and healthcare sectors, as well as sovereign states and individual clients in federal courts and in private arbitral tribunals. Mr. Ament-Stone has substantial experience representing plaintiffs and defendants in class action antitrust litigation and in environmental and industrial indemnity disputes. And finally, our very own conference co-chair, who needs no introduction, but I will give some background anyway, Jeff Klenk, focuses his practice on the application of economic theory to issues of antitrust, as well as to the analysis of damages stemming from commercial litigation matters. Examples of antitrust work undertaken by Mr. Klenk include analysis of alleged price fixing, tying and bundling arrangements, the use of conditional rebates, and resale price maintenance. In the context of damages, he has analyzed reasonable royalties and lost profit in patent infringement matters, lost wages in unemployment disputes such as wrongful terminations, and public interest and remedy issues. He also has significant experience analyzing issues associated with class certification, particularly in the context of alleged price fixing. So without further ado, I'm going to hand it over to our first panelist, Professor Joshua Davis, to talk about some of the initial findings of the 2019 antitrust report and how he sees that tied into the actual practice of these cases. So Josh?
Thank you. Can you hear me?
Yes.
Great. And I'm going to put up some PowerPoint slides. All right. So I have very brief remarks, and I'm going to divide them into two parts. One is the thank you part, and the other is the commentary on the report. But before I start up with the substantive piece, I do want to thank some real leaders in doing empirical research in antitrust. Huntington Bank has been just terrific, and so has Chris Ritchie, and so has Rose Kohles. And I just wanted to express my thanks for that. And in terms of writing the commentary, working with Diana Moss and Laura Alexander was also terrific. And Rose Kohles in particular not only did a great job organizing this panel, but did unbelievable work in support of the report that I'm going to be discussing just a part of. I really encourage folks to look at it. I think quietly Rose is an aspiring academic and would be successful one. One of the things I've learned as an academic is you actually don't have to be all that good as long as you work with really good people. And that is true for Chris and Rose and Huntington Bank and Diana and Laura Alexander. So that's my thank you section. I'm also presenting with Pam Gilbert, and you'll see I'm going to do a section, and then the same PowerPoint slides are going to segue into her presentation. And once again, you don't have to be good if you work with good people, and she's excellent. So here's some comments on the 2019 Antitrust Annual Report. There's a lot in there. I do encourage you to read it. I want to talk very briefly about some of the lessons we can learn from this new empirical research. This is now the second report. There was one in 2018. And the way that my presentation and Pam's together are going to fit is I'm going to talk about some of the data and why it's relevant to judicial practice. And then she's going to talk a little bit about the data and how it figures into and can inform legislative reform. And what I want to talk about specifically is what we've learned about attorneys' fees. Now, in general, there have been a lot of criticisms of private enforcement of the antitrust laws, and one form that takes is actually two forms that takes. One is it doesn't do anything, and the other is it does too much. It doesn't do anything means it just doesn't recover that much money. If it does, the money doesn't go to the class. The other is over deterrence. I and other scholars, I think, have made a convincing case, Bob Land, John Connor, that in fact, private enforcement and other enforcement is insufficient. There are too many violations because there isn't actually enough enforcement. So then the question comes, all right, it's insufficient, but is it still valuable? And I think that the empirical evidence is yes, it is quite valuable and quite efficient. What the report shows is that over the 11 years of study, private enforcers recovered $24 billion. It's a significant amount. And they did it, and those are nominal dollars. Really, if you put them in $20 dollars, the number would be higher yet. And then what this pie chart shows you from the report is that in the aggregate, 75% of those recoveries were reserved for the class. And so the criticisms, for example, that all the money goes to the attorneys or all the money that gets recovered is consumed in expenses, the evidence suggests otherwise. In fact, only 23% in the aggregate goes to the attorneys and only 2% is consumed by expenses. So I think actually that's quite a good story about the overall efficiency of private antitrust enforcement through class actions. Moving on from that, so the big lesson, I think, a big takeaway from this is, yes, private enforcement is very much worth preserving and to the extent judicial doctrine can affect that or legislative reform, it should be designed to maintain private enforcement. Now, in order to have effective enforcement, as a practical matter, we need incentives, and incentives take the form of attorney's fees. So let's talk a little bit. So here's the numbers summarizing. I don't know if the pie chart was fully legible, but class recovery is 75%, fee awards 23%, cost reimbursement 2%. So let's talk about, in terms of attorney's fees, what's the typical recovery? So that was the aggregate analysis. 75% of all the money is reserved for the classes, but this is now what's the typical or median spread? And again, the empirical evidence is interesting and maybe flies in the face a little bit of conventional wisdom, and it does so in part because many courts have suggested that a typical fee award in a class action is 25% to the attorneys. But as we found doing the overall median analysis for these 11 years of antitrust class actions, actually the median fee is 30%. And that can matter a fair amount because courts often, they use past practice, as folks know, as a baseline for current or future practice. And so in antitrust, at least, 30% may be a more realistic baseline than 25%. Going from that overall median, now I'm going to turn to this chart you can see in the right column, all the way in the right, that's the overall median. But the analysis that we did also breaks down the median fee by category, the median fee award by category as measured in as a percentage of the overall class recovery. And here we also see an interesting story in a bunch of ways. One is that courts will often say that the larger the fee award, the smaller the percentage recovery. And in part, they say it doesn't take twice as much work, for example, to get twice as good a recovery. But there is this countervailing doctrine, which says the better result that the plaintiff's counsel obtain, the bigger recovery they should get. So really, it's an empirical question about how these two things balance out. And then another statement that you often hear by courts is that any recovery of $100 million or more is sometimes dubbed a mega fund for purposes of awarding. And in mega funds, courts at the time said, a significantly smaller percentage fee award should take place. And what we see here tells an interesting story. What we actually see is, first of all, rather than as the overall recovery increases, there being any clear downward trend, maybe a slight downward trend, but it's pretty, actually there's more variation between categories. You can see, for example, 500 million to $1 billion recoveries, the third from last column, you've got a 28% median recovery. And then the smaller category, 250 to $499 million, $500 million, a median of 25%. So you see a 3% variation there. And as you go up and down the row, you actually see pretty consistently somewhere about 28 to 30% as a mean. And of course, the overall mean we know is 30%. So that's interesting. If there is a mega fund category, it would appear to be over $1 billion in antitrust, at least. Not, maybe different in other areas of the law, but $1 billion. And I'll make one last point about this. Brian Fitzpatrick, in his book that he spoke about yesterday, in one part of it, he actually talks about a criticism of this notion of mega funds or discrete drops. And one of the things he says is, first of all, we want incentives for larger recoveries, so we shouldn't have decreases at all as funds get larger. We want incentives for counsel to obtain a lot for the class. And then second of all, you can get into some very odd and perverse incentives if you have discrete drops. And so just to give you an example, if you look at the 500 to 999 million category, the typical fee is 28%, over $1 billion, it's 14%. Now, if that were truly a cliff, if a recovery in excess of $1 billion means that you suddenly drop to 14%, you could get these bizarre circumstances like this example where if class counsel recover $990 million, let's say they get a typical fee award of 28%, they would get a $280 million fee. If they obtain $1 more million for the class, they then would get a 14% overall fee, and their fee award would be roughly cut in half. And that's not the kind of incentives you want to create. And so what Brian has argued for, and I think he's right, is even if you're going to have decreases, it should be like a tax rate where it's progressive. Any recovery above a certain amount is subject to a lower percentage recovery, but it doesn't affect any dollars before that. I'm skeptical that, in fact, courts are this silly in terms of the incentives they create, but I'm doing additional empirical research, which involves regression analysis to try to figure out if there are structural breaks, as econometricians say, to see if it really is progressive or not. And but that's for another day. So those are my comments. This is just the tip of the iceberg. There's so much more there. I encourage you to read the report. Thanks very much.
Rose, do you have me next to just jump in, or how do you want to do this?
Yeah, please go ahead.
Sure. So that was great, Josh. And so before I started, we wanted to have a little give and take on the panel. So Josh, I really enjoyed just listening to you just now, and it's very, very interesting, this data. I was just wondering if you took from this data any ideas that you would have for reform, because you started off by saying you have done and others have done empirical research concluding that private enforcement is actually insufficient to be deterring antitrust crimes. And now you look at this data, do you come up with any kind of reforms to buttress the private enforcement system? Yeah,
that's a great question. Thank you, Pam. So I think there are, sorry, I'm having some lighting issues. It's either too much or too little, but I think that there are a bunch of options for reform. I think this story in part tells us that probably the changes in the law that have taken place in antitrust in the recent decades that make private antitrust enforcement more difficult probably should be undone. And I would, if I had to focus on certain things, I would say pre-dispute mandatory arbitration would be very much worth revisiting that and allowing plaintiffs' antitrust class actions to get into federal court. And then I would revisit some other basic issues like the motion to dismiss standard under Iqbal and Twombly, sometimes called Twickball, summary judgment standard, class certification. I think all of these procedural impediments are well worth revisiting, seeing that private antitrust enforcement is insufficient, but also very efficient and valuable.
That's great. That was a great answer. And I think now I'm going to just launch into my remarks this morning. If that's okay. Is that the right process? Great. Which I think kind of follow from some of the ideas that Josh just talked about. So good morning, everybody. And it really is an honor to be on this panel with such illustrious panelists. So I'm going to talk today. I'm going to focus on one piece of antitrust cases and also of the data that was in the antitrust report. And these are antitrust cases that are brought by direct purchasers and indirect purchasers. And I'm going to refer to some of the data in the antitrust report to talk about the differences in recoveries by these different classes of plaintiffs. But first, a little background. So in 1968, the US Supreme Court decided a case called Hanover Shoe versus United Shoe Machinery Corp. that held that an antitrust defendant cannot assert a defense that an antitrust plaintiff passed on the illegal overcharge to a subsequent purchaser and therefore did not suffer injury. The plaintiff, according to Hanover Shoe, need only prove that there was an overcharge and the amount of the overcharge. And then in 1977, in a case called Illinois Brick versus Illinois, the court relied on Hanover Shoe in deciding that if a pass-on theory cannot be used by the defendant against a direct purchaser, the theory also cannot be used affirmatively by a subsequent or indirect purchaser to prove that it was harmed because the overcharge was passed on. And ever since Illinois Brick, the rule in the country in general is that indirect purchasers may not bring claims under federal antitrust laws. And while Illinois Brick was seen as a very anti-consumer, anti-enforcement decision at the time, both Hanover Shoe and Illinois Brick have now been the law of the land for decades. And actually a very vibrant private civil enforcement structure has arisen. And you saw some of the data that Josh just talked about. So in the approximately 40 years since Illinois Brick, more than 30 states have made remedies available under their state laws for indirect purchasers, either through new statutes or through interpretation of existing statutes. So now many large antitrust class actions involve direct purchasers bringing federal claims and indirect purchasers, often consumers, bringing state claims. And then in addition, because Congress passed CAFA, the Class Action Fairness Act in 2005, most of these cases are now brought in federal court. So the federal claims and the state claims are in one jurisdiction in one federal court. And procedures have now come up, have been designed that make these cases actually work and function pretty well, that involve discovery and pretrial rulings that are all consistent and in one court. And so those procedures now preserve the rights of the injured parties, including states' attorneys general and consumers and direct purchasers. And their rights are protected as well as the rights of the defendants to defend the claims. So in short, I would say that the system is actually now working pretty well. And now the antitrust report adds to the data that we thought the system was working well, and now we have some data to show what is going on. So Josh, I think you put up the first slide I was going to use. Thank you. So this chart shows a very large gap between recoveries by direct and indirect purchasers over the years that were studied. So direct purchasers recovered an aggregate of $20.2 billion, or about 84% of total recoveries, while indirect purchasers recovered $3.5 billion, or only 15% of total recoveries. And then if you go to the second slide, it shows the numbers behind the numbers. And we see that there were over twice as many direct settlements as indirect settlements, 669 versus 289. And then the recovery per settlement for directs was much greater than the recovery per settlement for indirects, 30 million versus $12 million. So now the data show that there are many more successful direct purchaser actions, and each direct purchaser action on average recovers more than each indirect purchaser action. And this data is really very important for us when we look at an ongoing debate. And the debate is whether we should, in fact, through the courts or Congress, overrule Illinois Brick. And as I said, pro-enforcement, pro-consumer voices have been calling for that for many years. The rationale makes sense, right? Because consumers, because these overcharges are often passed on through the chain of distribution down to the ultimate end user, the consumers pay these overcharges. Shouldn't they have the right to go to use the federal antitrust laws to go to court against the antitrust conspirators? So, but I'm going to argue, in fact, that overturning Illinois BRIC would actually seriously weaken private antitrust enforcement by making it very difficult in many cases to bring any successful case against antitrust conspirators. And again, I'm going to look back at the data, and the data is consistent with what we already know. Indirect cases are generally more difficult to prove than direct cases, and they generally recover less. And it makes sense that it would be easier for the direct purchaser who's in the direct, has a direct relationship with the antitrust conspirator to prove that they were harmed by the antitrust violation. And it is easier for them to prove their damages. And then furthermore, and this brings us back to the Hanover Shoe discussion, if we did overturn Illinois BRIC, there's a very good chance that Hanover Shoe would also be overturned because those two cases are seen to be so intimately connected. And that would mean that antitrust defendants would be permitted to use that pass-on defense and argue that direct purchasers passed on the overcharges to subsequent purchasers. This could make it very difficult for direct purchasers to bring antitrust cases, leaving a lot of private enforcement in the hands of indirect purchasers. And what we saw from the data is that this could eliminate the vast majority of recoveries from antitrust violators, really seriously eroding the deterrent effects of private enforcement. And there's furthermore that indirect cases face considerable challenges in the courts in class certification and proving damages. And so those leaving it in the hands of indirects may really harm enforcement furthermore, because some of those cases just might not be able to survive. And you could end up with the unintended consequence of eliminating private enforcement in many important antitrust conspiracy cases. But again, admittedly, if you leave Illinois BRIC in place, you are leaving this system in which many consumers across the country live in states where they cannot bring an antitrust case. So I'm going to leave you with one other possible alternative, and that would be to reverse Illinois BRIC, but to leave Hanover Shoe in place. If we did that, direct purchasers would be able to continue to bring the cases that they can bring today under the current rules, but indirect purchasers in those states that can't bring their cases today would be able to use the federal antitrust laws to bring their cases. And I think we have a polling question that's going to ask you, the viewers, what you think of this idea. And I'm going to stop it right there.
So while we wait for the polling questions to come in, or the responses to come in, Jeff, I know you had some interesting thoughts around Illinois BRIC and whether or not it should be repealed. So can we take a minute to hear from you, and then we'll take a look at how the polling has responded?
Sure, and thank you for those remarks, Pam. I found them very interesting. And I found myself agreeing with you right up to the very end, where you suggested repealing Illinois BRIC, but leaving Hanover Shoe in place. But as an economist, I agree that the issues that you're wrestling with as an attorney look very similar to the ones that I'm wrestling with. And I tend to agree that if we were to repeal Illinois BRIC and or Hanover Shoe, that private enforcement would be less. But as an economist, so often I do see evidence of the overcharge being passed on through various chains of distribution. And so that suggests to me that oftentimes the direct purchasers, while they may be an efficient enforcer of antitrust laws, oftentimes find themselves reaping a bit of a windfall because they are able to pass along those price increases. So I think as a matter of economics, it probably does better align awarding damages to those individuals who experienced the overcharge. But I do appreciate that tracing the overcharge through various levels of distribution and the strategic decisions that come along with whether or not one passes on the overcharge or not can be fiendishly difficult to work through. But relative to the 1960s, I think economists are much better equipped to do so, that they have much better statistical mechanisms to isolate the overcharge at each level of distribution. So I really appreciate you sharing some of that insight, Pam.
Sure, and I'm far be it from me to start fighting with an economist over these issues, so I'm not going to do that. But I do want to sort of go back again to something that Josh began with, which is, when you look at the empirical evidence of, in antitrust cases and the actually what's going on in the real world, nobody's getting a windfall. That we rarely, if ever, even find actual damages being paid out in any antitrust case. So the fear of, windfalls or some unfair impacts on antitrust defendants because they're going to be overpaying in these cases has just not turned out to be true, and we don't see it. So I think that we don't have a fear at the moment that we're going to be over deterring, and we still have the problem of under deterrence that we're working on.
Well, thank you, Pam. We are going to go next to our panelist, Nathaniel Ament-Stone. And Nathaniel, you can start off with responding to Pam and Jeff's comments, or if you so choose, you can dive right into some of your points.
Thank you so much, Rose. I'll just jump right in. I'm going to talk briefly about a recent class certification decision from the Southern District of New York in the aluminum warehousing case. This case is kind of convoluted and hard to understand if you're not familiar with it. Essentially, this is a proposed class action, Section 1 of the Sherman Act, alleging that some major banks and financial companies conspired to raise the price of aluminum, and particularly to raise a component of the price of aluminum called the Midwest Premium. And it's not a traditional, meet in a cigar-filled back room and decide what the price of aluminum is going to be type allegation. It's a little more complex than that. Essentially, the allegation is that these defendants used their positions owning warehouses where excess aluminum is stored to create stockpiles, create what's called critical mass, high quantities of aluminum in the warehouses, and that by doing so, they were able to raise the Midwest Premium component, and that by raising the Midwest Premium component, they were able to raise the total price. So this case has actually been going for 7 years, and it was on appeal on an antitrust standing issue at the Second Circuit for 3 years. And so we just had a class certification decision in July, and it went a little something like this. The court looked at the Supreme Court's Comcast decision, which is about the role of expert evidence at the class cert stage, and particularly in the antitrust context. And what the Supreme Court said in Comcast is the class at the class cert stage must put forth expert evidence, of the economic nature in an antitrust case that is consistent essentially with the plaintiff's theory of liability. The experts' models have to be capable of showing class-wide damage based on the theory of harm the plaintiffs are alleging. It can't model harm on a completely unrelated theory. So that sort of is the baseline from which the defendants' challenges to the plaintiff's experts' model in aluminum proceeded. And the judge was looking at Comcast, and he was looking at two other relatively recent decisions. One is rail freight in the DC Circuit, which was about uninjured class members. You can't have a model that yields a lot of false positives because, of course, you need to be able to show harm to all or nearly all of the class. And in the Lamictal case in the Third Circuit, you can't use averaging to show class-wide damage, because if some class members were injured and some were not, you can't just say, well, on average, the class was harmed. So the court, in a rather painstaking 100-something page decision, really took a deep dive into the plaintiff's experts model. Now, first of all, the plaintiffs were not just using econometric evidence here. They were also pointing to some documents that from market participants discussing the aluminum industry that they said underlay their theory of harm, that warehouse queues caused a higher Midwest premium, and that could raise the all-in price. The court was not persuaded by this evidence, and it raises an interesting question as to whether and to what extent plaintiffs can use documentary evidence at the class cert stage, considering their Comcast obligations. But I don't want to get too into that. So what did the plaintiff's model show? It modeled essentially what would warrant cancellations, which is the procedure that aluminum purchasers use to load out metal from a warehouse. What levels would those have been at if there were not the alleged conspiracy, and used certain control variables to show that, and also to show the relationship of the Midwest premium and the all-in price. And I'm really sort of breezing over the details here because we don't have a lot of time. And importantly, the models also relied on a sort of combined impact from the queues in Detroit, which is where most of the allegations were focused, and the queues in Vlissingen, Netherlands, which there are some allegations about, but the class was alleging the relevant market was the US. So that's important in a moment. The court looked at the plaintiff's model and said the following. First of all, this model averages impact across the class to show class-wide harm. It averages pass-through analysis to show that a higher Midwest premium affects the all-in price. And citing Lamictal, that is not a competent way to show damage to the class. There was also the problem of relying on sort of the combined impact of the queues in Detroit and Vlissingen. You're showing class-wide impact by mushing together what was the impact to the price from queues in these two cities, instead of isolating the two. When the relevant market is the US, the relevant premium is paid in the US, and the expert really should be capable of isolating just Detroit. Again, this is a really complex opinion. It's the In re aluminum warehousing antitrust litigation. I highly recommend digging into it, but I think one of the major sort of policy questions coming out of this is how perfect should the plaintiff's model be at the class cert stage? It's clear the Supreme Court was saying judges should not just throw up their hands and say, well, battle of the experts, it's for the jury to decide. What the Supreme Court, I think, was getting at is, these models are very complex. Jurors are likely to be confused by them, and we should make sure at a relatively preliminary stage of the case, which is to say class cert, when we need to determine, is commonality met, is predominance met, adequacy, all of these things, will the plaintiffs actually does their theory hold water, and will they be able to show damage to the class, or are we wasting our time here? Now, one little procedural spin to this case, which is interesting, is yes, there was a class case. There are also parallel individual suits by companies that would fit within the class definition. And that's very unusual. Usually, you would not have other plaintiffs until the opt-out phase. So by rejecting class certification, the court did not, in fact, bring the whole case to a halt. There are still individual companies bringing suit. But how, what level of economic detail do we expect at the class cert phase? Should experts really incorporate every possible relevant variable? And there were some very persuasive critiques of the omitted variables in the plaintiff's model from Jeff's firm, many of which the court adopted. And then one other point that the court didn't actually decide that I think was particularly interesting in this case is, are conflicts of interest or of benefits among the putative class a compelling reason to deny class certification? In this case, the class definition included a lot of trading companies who, as part of their regular aluminum business, engaged in many of the same tactics that the class was claiming were part of the conspiracy. So clearly you cannot have class members who were participants in the alleged conspiracy and who benefited from it And the court did not need to reach that issue because it had so many issues with the economic model in general. But it's a very interesting decision, and I'm probably out of time at this point, so I will turn it over to Jeff.
Well, thank you, Nathaniel. And I appreciate that you did the explanation of aluminum warehousing so that I don't have to go into that factual background. But Josh or Pam, do you have any thoughts you want to share on what Nathaniel said, or should I go ahead?
I do. I'll give a very quick one, but if you don't mind, and that is just, so Rose asked Nathaniel whether he wanted to comment on the discussion between Jeff and Pam or really anything else. And Nathaniel said he was declining, but I don't think he was declining. I think, in fact, what he said had profound implications for the discussion that preceded his very interesting and thoughtful and insightful comments. And, you know, it comes back to Pam's response, I think, to Jeff, when Jeff, you'd suggested, oh, well, we've got these economic techniques, and so we can now do these things that we used to not be able to do. And then Nathaniel said, but Jeff, your firm, you know, it might have even been you, brilliant that you are, brilliant that your firm is. It turns out that there are all these procedural issues that can make it impossible to enforce a case, an antitrust case, effectively. And note this, it was a class certification decision. That means if the judge did it at all right, the judge did not decide whether plaintiffs should win and how much the damages would be if they did. The judge just said, there's too many individual issues, there's difficulties with the model, but we don't actually know. At the end of the day, there might have been an antitrust violation with hundreds of millions of dollars of damage. And I have some, you know, small disagreements about, or questions at least, about how you articulate the relevant standard, not as the judge imposed it, but as it should be. But the main payoff is, yes, there are all these practical procedural difficulties, and they are so much more significant in indirect cases that we know empirically, for there to be successful prosecution, you need to have vibrant direct purchaser cases without pass on. And it's not a theoretical question about what models might be able to do, Jeff. Clever economists like you are going to undermine the plaintiff's case a lot of times. Maybe you're right under the current standard, but it does mean that it's very difficult to prosecute these cases. And if we make it more difficult, we'll have even less effective enforcement and more antitrust violations. Anyway, that's my comment.
Nathaniel, any thoughts?
I mean, I'm a very active associate in the aluminum case, and I have my views on the merits, and I think that really if and when we get to the merits phase, the plaintiffs are going to have some problems. But you know, even just looking at it as a class case, the theory of liability here involved so many steps and was so unconventional that I think I do not envy the class's task in trying to come up with an econometric model that that held up and that modeled that damage across the class, because the class as defined kind of invited a lot of individual questions. And in terms of antitrust enforcement, it really doesn't have consequences for many major companies that are still, as I said, individual plaintiffs in this case. Those cases are proceeding. So we'll see actually on the merits how this case turns out, but it was a problematic case for class cert and an interesting test of the Comcast standard.
Well, let me get started then. And as both Nathaniel and Josh alluded to, my firm, Berkeley Research Group, was retained to offer economic analysis in the aluminum warehousing matter. And I supported our testifying economist, David Kaplan, in this case. He was one of two experts retained by the defendants. And when I read Judge Engelmeyer's decision in aluminum warehousing, what really jumped out at me was the length of time that he took to discuss the Daubert opinion that plaintiffs had brought against David. And, you know, I know in preparation for this panel, talking with Josh and others, I think there's a real question here as to whether or not it makes sense to even bring a Daubert motion at the class certification phase of the case. And I know Josh, he's nodding his head, and I know that he has some thoughts on this, so I will let him share some of those thoughts in a moment. But let me just raise a couple of initial points here. that one of the tactics that the plaintiffs took was challenging David's credentials as an economist. And for those of you who know David or have worked with David or against David, I think you all realize that he's a very accomplished economist with a very deep set of credentials. And so I don't know that there was value then in forcing the judge to undertake his own fact-finding mission to figure out what David's credentials were. In fact, it led to language such as this. Mr. Kaplan is an extensively qualified economist with ample training and experience in the field of econometrics. And as the plaintiffs, I don't know that that is necessarily the evidence that you want to be adducing and forcing the judge himself to come up with and write. And in fact, the judge's response to the Daubert motion was 20% of his overall opinion denying class certification. So the judge took it seriously, and it forced him to confront evidence that he might not otherwise have found it necessary to confront. Setting aside that debate, as an economist, what I took out of the aluminum warehousing decision was really twofold. And Nathaniel's touched on one of the issues, but the other issue he hasn't. So let me start off with that. And that is this issue of ascertainability. And for those of you who practice in the class certification space, which I imagine most of you do, ascertainability is really the issue of whether or not you can determine who the proposed class definition really applies to. Now, the plaintiffs challenged the admissibility of David's opinion here, claiming that he was really offering a legal opinion, that he was usurping the role of the lawyers, or in fact, even the finder of fact himself, by weighing in on ascertainability. Now, as an economist, I would disagree with that on really two grounds. First, one of the key roles of an economist at the class certification phase is to address issues of possible adverse impact and how the challenge conduct may or may not have affected the proposed class. But without knowing, as an a priori matter, who's in the proposed class, it's really difficult then to look at issues of adverse impact. I, as an economist, need to be able to draw a circle around who's inside the class and who's outside the class, because where that circle is drawn could really affect whether or not all proposed class members were impacted by the challenge conduct, or whether only some of the proposed class was affected by the challenge conduct. So I would view ascertainability as really a threshold question to addressing some of the other very important questions that economists have to address. The other thing here, though, and Nathaniel alluded to this, is that this was a complex case. And one of the ways in which the proposed class was defined was that it only included so-called first-level purchasers of aluminum. So if you repurchased aluminum that had already been bought and sold once, then by the proposed class definition, you would be excluded from this case. Now, the first-level purchase of aluminum, that might sound easy to figure out, but in fact, there is a vibrant market whereby aluminum is bought and sold multiple times before it ever gets in the hands of someone who might actually be using it, a so-called fabricator. And so one of the research assignments that David had to undertake was researching the supply chain or the distribution chain of the aluminum industry, and just showing how many times aluminum can exchange hands, even among smelters of aluminum, those people that would otherwise take raw alumina and smelt it into aluminum. And so the judge pointed to David's work here and said, this is very clearly within the purview of an economist. Undertaking distribution and supply chains is work that an economist does, that an economist routinely does, and is in fact very important for determining this issue of ascertainability. Moving on then, and this is the point that Nathaniel alluded to, the judge wrestled with this idea of possible benefits and possible conflicts among proposed class members. That, as Nathaniel noted, included in the proposed class were traders who engaged in conduct very similar to conduct that the defendants engaged in. And yet the plaintiffs were claiming that when that conduct was engaged in by the defendants, it was anti-competitive, but yet when other entities engaged in it, it was perfectly fine. And so an example here would be the canceling of aluminum warrants, or the loading in of aluminum into certain warehouses, or receiving incentive payments for the loading in of aluminum into these warehouses. And there was a lot of evidence that many proposed class members had done that. And so that really raises two interesting questions: that to the extent the defendants benefited from that conduct and earned higher economic profits as a result of that conduct, would it then be appropriate to attribute those same economic benefits to proposed class members and view that as an offset to any putative adverse impact they may have experienced? The other issue here is whether there is a conflict of interest, that to the extent it is adjudicated, or to the extent that the class representatives or the named plaintiffs are claiming that it was illegal to cancel warrants, and you are a proposed class member that also canceled warrants, do you really want to be in the same class where your representatives are saying that the very conduct you engaged in was anti-competitive? That you might want to be in a class against these same defendants, but you might want to be pursuing a different theory of legal liability. And so let me just read to you a moment a couple of passages from the judge's decision. So with respect to the question of benefits, Judge Engelmeyer did say, or did agree, that David's opinion that analyzing any such offsets necessarily would be an individualized inquiry. Judge Engelmeyer said that is an appropriate critique of the conclusion of the plaintiff's experts regarding the impact of the alleged conspiracy. So very clearly, the judge thought this was a relevant inquiry to undertake. But this does then get into the issue that Nathaniel raised of whether raising the issue of benefits somehow falls afoul of Hanover Shoe or Illinois Brick, or it somehow involves invoking a pass-on defense on behalf of the defendants. As an economist, I do not believe that it falls afoul of Illinois Brick or Hanover Shoe, that these benefits are very different. They're distinctly cognizable as something independent of the antitrust overcharge itself. And so I do not believe that this is what Illinois Brick has in mind when it is talking about, or Hanover Shoe has in mind when it is talking about the passing on of an antitrust overcharge. As Nathaniel noted, though, Judge Engelmeyer largely did not get into this issue. He acknowledged that it was a relevant inquiry to look at benefits. He acknowledged that looking at benefits could raise possible issues with respect to Hanover Shoe or Illinois Brick, but he declined to make a ruling on that basis either way, because he found other reasons to deny class certification. But he did say that in the event that the court's holding here that Rule 23b3 is not met on account of the lack of common proof of antitrust impact, and then were that ruling overturned, a searching inquiry into the issues of benefits and possible class conflicts would then become necessary. And so what I take out of this as an economist is that it is well within the purview of an economist to look at possible benefits and possible class conflicts, and just to present the economic evidence as it is, and then really force both the attorneys and the finder of fact to confront the implications of that evidence.
So Josh, I will give you 1 minute to respond, and then we do have a question from the audience.
Yeah, so let me respond in 1 minute. So that was a very rich and interesting presentation, and I won't try to touch on many of the issues that were raised. I do want to go back to the very beginning where Jeff, you said, you questioned the wisdom of bringing a Daubert motion, particularly a Daubert motion that challenges the credentials of an economist. I think there's a lot of wisdom strategically in that question. One of the things I feel like I've found over the years being exposed to practice a lot and to academia is in law school, we teach lawyers what to say, and then in practice, they have to learn what not to say. And this is one of those instances where, sure, you can make the argument, but if you have, you know, an economist who's well within the range of a competent expert normally would be admitted, to focus the judge on the credentials of the economist, sure, you can do that, but it just seems like a very questionable place to focus your energy. And I actually think there's a deeper lesson there. I think there are lots of motions under Daubert, under motions to dismiss for summary judgment, that force a judge to decide an issue in a posture that is not favorable to the moving party. And it's very hard for lawyers sometimes who can get caught up, who can believe their own hype, I'll say, to keep it clean so it's safe for work, that they end up making motions that really aren't wise strategically, because then they get an unfavorable ruling where they might have gotten a more favorable one in a different posture if they'd been if they'd had more, exercised more restraint.
Well, and Josh, I don't know if you wanted to touch on this, but you had mentioned with respect to that very last point that there are differing standards for Daubert motions in class certification. Is that really what you were getting at with your last point?
I think that's, I absolutely do think that. And once you get an unfavorable ruling on a Daubert motion that's related to a class certification motion, I think your prospects are much worse on class certification. Often it's better to just engage that directly. And under Rule 23F, this is really in the weeds, but it is much more difficult to challenge a Daubert motion on interlocutory appeal than the class certification decision itself. And so you can get yourself in this very awkward posture where you get an unfavorable Daubert ruling and you really have no way to get at it very directly when you're appealing an adverse result at class certification. So I think there's lots of technical and not less technical reasons to exercise caution.
Great. So I hate to cut this off, but we do have a question from the audience, and I want to make sure that we get to it, given that we only have a few minutes left. So this question is posed by Barbara Hart of Lowy Dannenberg in New York. If the goal is deterrence, the law says the inexactitude of the damage is a function of the defendant's conduct and should not act as a get-out-of-jail-free card. Why is average impact unacceptable?
If I can quickly take this one, I think it has to do with commonality and predominance. If you're able to show on average people overpaid by $5, that's great. But if 30% of the class made money and the other 70% paid $10, that's going to be a commonality problem.
I think though the question, just to respond quickly, I think the question is, yeah, but why is that the standard? And I think it's it's not an easy question to answer, because the truth is when you go to trial in an antitrust class action, the jury is never asked, is there widespread impact? The jury is asked, is there liability and how much damages did the class suffer? And the real question is, why not have that be the legal standard, and why care so much about common impact at class certification? I think it's an excellent question. I mean, it's a lot like wage and hour context, Tyson Foods, where the courts have said you can use statistics and even averages. And in fact, they did so based on antitrust case law that this person's question about, Story Parchment, Eastman Kodak, this long history of antitrust cases saying approximating damages is okay when it's the defendant's wrongdoing that makes it hard to figure out things like how widespread the impact is. So I think it's a very deep question with a lot of force behind it. If one doesn't assume current class certification doctrine is what it currently is. Yeah.
Well, as an economist, I would have a number of bases for disagreeing with showing average impact, but I know that we're out of time. So let me turn it back over to Rose.
Okay. Well, thank you to each one of our panelists for sharing your expertise this morning. I think we had a lot of great dialogue and a lot of back and forth between each perspective. And to Jeff's point earlier, that's exactly what we're looking for at the Class Action Money and Ethics Conference. So once again, thank you very much to everyone.
Thank you.
Thank you.